I put them up here in the same order that they appear in the forms directory. So if you go to Form Simplicity or you go to Transaction Desk or Zip or wherever you use your forms from, these will appear in this order. One of the things that you have to understand is that there are so many forms that are called addendum to contract, and then there's what they really are. So you have to really go through them slowly to find them in the forms directory. And then there are a lot of forms that say amendment to contract and the same thing. So if you're looking for something, they all start with those terms. That can make it hard to search. However, the other thing I want you to remember is just because something's called an amendment doesn't mean that you can't use it as an addendum or vice versa. So just to refresh your memory, an addendum is something you're attaching to a contract form at the time that you're signing it, the time it's originally being created. Okay. An amendment is something that changes the terms of a contract after it's been signed. But don't get hung up on the names of these things, because there are some amendment forms that I can see being used as an addendum. There are certainly some addenda that I can see being used as an amendment being signed after the contract was executed. So don't let that stop you from using them. It's the content of the form, not title, whether it's addendum or amendment, that makes a big difference. So with that explanation, the other explanation I want to give you is remember that there are other sales contract forms in use. We see more and more of our bar contract forms. Folks in Miami like that one. That's a one-size-fits-all for the whole state. They tend to bring that with them. But if you mix and match addenda or amendments with the contract form from another form, they may not work because there are defined terms in the contract that are carried forward into the addenda and amendments. And there are other issues with respect to creating conflicts, so don't do that ever. If you can't find an amendment or an addendum that goes with the NABOR contract that you want to use, call me and I'll try to find it for you and I'll send it to you off of Form Simplicity. But other than that, don't mix and match, because it's just a recipe for disaster. And I think we've got almost everything covered. I had a broker contact me a few years ago and told me that we didn't have a form and had to go to the Fort Lauderdale, at that time, the Fort Lauderdale website to get a form to attach to the NABOR contract, which I think is a terrible idea. But I was also happy that he bet me a dinner. We didn't have the form, and of course I was happy to bet him because I know the forms and we have a form. But I didn't collect the dinner because I was kind and I let the fellow go on about his business. But the point being, I think we've created addenda or amendments for almost everything that you're going to bump into in a residential real estate transaction. So rather than trying to fill the blank lines in at the end of the contract, you're much better off using this, because Legal Resources Committee that prepares these, literally spends forever fretting about a word. And so if you're writing something up real quick, it's not going to be anywhere near as good as this is going to be. Okay. All right, so again, going back to the forms, we're going to start the same contract, the same order that they show up on the website. The first one is the addendum to sales contract. Seller's right to make a backup contract, primary contract. So again, these are going to be a little out of sync because they don't show up in the right sync, but this is a form that you will use if you have created a backup contract. And this is the form that you then convert that backup contract into the primary contract. So you fill out the seller and the buyer's name, and you talk about the property, and whatever the contingency was, you put that in the contract as contingent on. So if the backup contract was contingent on the first contract falling through, that's fine. You put that there. Then the rest of the paragraph here talks about that it's in the MLS service. Seller has the right to continue to market and show the property, so you know that if it goes in as pending or even contingent, the seller still, even if it's been turned into MLS, can still market it. So this again turns the contract into a primary contract. Then in the paragraph where it says the purchase of the property, and we're looking at that, I think I can get this thing to work right here. The purchase of the property, buyer shall notify the seller of such election, deliver an additional deposit to escrow in the amount of blank, not later than 3 days after receipt of notification of the backup contract. So this is when you're going to tell the seller under the primary contract that you're going to make a backup contract primary. Okay? So you've got that, you've got it to contingency, the contingency is not met, and I've seen that happen where we've got something that the first contract is contingent, for example, on some arrangement happening. This way you can turn the backup contract into primary. Okay, moving on to the next form. This one we don't use too much. We're getting most of our pre-78 houses torn down. But this is the form that you will use on a lease if you're going to show that you've got a lead-based paint or lead-based paint hazard. Some of you end up doing leases with properties that don't sell. I've done in the past few years a few lease to own where they have an option to purchase. I just want to let you know this form exists. I'm not going to go through it in great detail because you're probably not going to use it very often. We've got the addendum listing contract. So again, you want me to go through the listing contract addendums? Show of hands. Okay, no, these are the same forms. We're not going to get new forms until the end of this year. Okay, we'll speed through the listing contract forms. This right here at the bottom, the addendum to sales contract, that is probably the most dangerous form in your arsenal because as you can see it, it's a big blank page. So y'all are authorized to fill in the blanks on pre-printed form contracts. You're not authorized to draft. That's the practice of law. And I just saw a case where a realtor was found guilty of unlicensed practice of law, I think for preparing a lease. But here you've got this addendum. It says other terms and conditions, and that's pretty much the equivalent of those blank lines at the end of the sales contract. So I'm going to encourage you to pretend this doesn't exist and don't ever use it. And if you're going to do this, get an attorney to draft something for you because I think more than likely you're going to find that we've got a form that'll fit whatever the problem is that you're trying to address. And I'll give you a good example of that. We're going to have a contingency, which I've seen more in the past few years than ever before, contingency on sale of the buyer's property. So they're going to make the contract to purchase this property here on Marco, contingent on the buyer selling their home up north, for example, okay, or another property here on Marco. So I see realtors fill that in on those blank lines at the bottom of a contract, and they go, this is contingent on the buyer selling their existing home. Maybe they'll even put the address, 284 Bald Eagle Drive. Well, that really isn't what you intend most of the time because the question is, when is it sold? When it goes under contract? Is it pending? I think what you're really looking to do, and our addendum does that, and I'll show you, you're going to close that buyer's home sale so get the money ready to buy the second home. And if you don't have that in there, now you've set up a situation where the parties are going to argue about what that means instead of using the addendum. So that's a problem that you can avoid by using the forms that have already been created. But this is an example where somebody might be tempted to do that. Okay. This might be more tempting to a northern attorney who for some reason think that they can get involved with doing Florida real estate transactions. Okay, now this is one that I do see happen, addendum to sales contract review by advisor, and this is for the buyer. Now, every once in a while you'll have a buyer who says, I want to look at this, but I have to have my financial person look at it. Or I want my lawyer in Chicago to look at it. Or I want my mother-in-law to look at it. Okay, so those are all advisors that these folks want to get involved in the transaction, and although you don't necessarily want to do that, this is a way that you can get a contract signed and give them some time to have their advisor advise. So again, you fill in the bona fides of the transaction on the seller and the buyer line and then the property description. And this is going to be attached as an addendum, so you'll be in good shape there. And then the paragraph says buyer shall have blank days after the effective date, the review period, to have this contract reviewed by the buyer's accountant, attorney, or other advisor and may terminate the contract for any reason during the review period. So what does it do? It really does create an option contract. So the buyer has whatever number of days you put in this blank to terminate the contract, and if they don't terminate, then the period is waived. Now, is time of the essence for termination? Doesn't say that it is, and under the NABOR contract, time is not of the essence. So it may not be of the essence, but be really careful that you don't miss the date just to be safe, all right? But this gives your buyer a comfort level that if they really didn't want to talk to their financial person or they want to talk to somebody else, whoever their advisor is going to be, maybe their stockbroker, to make sure they have funds available, whatever it might be. They can do this. Okay. We have the same form for the seller. Addendum sales contract reviewed by advisor seller. So here you might have the seller who wants to talk to their tax person to make sure that they're not getting nailed on taxes. I just had a deal today that the question I asked was, okay, what's your basis in the property? And my client says, well, I've rented it and I've depreciated it all the way down to zero. And I said, well, then you'll be paying income taxes on 100% of the sale proceeds. And she said, yes, that's very bad. That's why I haven't signed the contract yet. I'm going to talk to my tax advisor. And I said, well, I think that might be a good idea. I explained 1031 exchanges and some things. So we may still be able to hold that deal together. But the point being, you know, she wanted some time. And if the realtor was offering this as an option, the realtor could still have a signed sales contract, albeit the seller has the opportunity to back out after talking to the seller's advisor, but you're a whole lot closer to closing with the signed contract and an opportunity to back out than you are with somebody thinking it over and may or may not sign a contract in the future. So these are two really good forms to allow you to proceed with a transaction and allow the customer to get the advice that they need to make that final decision. Okay? Anytime anybody have any questions, please raise your hand. Happy to answer all of them that I can. Okay, this is the form I was telling you about as an example a little bit earlier. So this is the addendum to sales contract, sale of buyer's existing property. This form is a good form. It's not perfect, and I'm going to go through and show you what about it is not perfect but makes it usable. Okay, so I'm just going to kind of skip through the top part, which talks about the seller and the buyer description of the property, because that's on all these forms. But we get down into the meat of this particular addendum. And it says that the buyer's obligations are contingent on closing of and disbursement on, and this is what I talked about earlier. I think that's what everybody's really talking about when they're making a purchase contingent on the sale of the buyer's property. And this doesn't have to be the buyer's residential property. It could be any property the buyer was selling. So they've got a rental property, they're going to buy this one. They've got their home they're going to use, or whatever they're going to do, they can do this. And this is the part here that may or may not apply, so you have to be careful when you're using these forms that you understand what they say. Right here, which is presently under contract. Okay? So if you've got a deal, and I had one just a couple of months ago, where the buyer wanted to make it contingent on the sale of the buyer's home, but the buyer's home was not presently under contract. It wasn't even on the market yet. Okay, but they had been out kicking tires and found a property they really wanted to buy, but only if they could sell the home they got. Okay.
Why don't you make it tougher then? You know, underneath the contract.
Make what tougher?
Well, just presently underneath the contract, where is a copy of it? It doesn't say in there that a copy is going to go to anyone.
Well, the key is that we're trying to make these as user-friendly as we can so we don't make the transaction too fouled up. And got to remember, these are drafted by brokers and attorneys that sit together on a committee at Legal Resources, and they come up with, here's what we think we want to do. Now, on the committee, the reason it says which is presently under contract is because the thought was there aren't too many sellers that are going to be real keen on entering a contract to sell something so that the buyer can go out and start prospecting and selling their house. Because how many of us have ever seen a seller that wants to overprice their market when they list it? I mean, I had that happen to me years and years ago. Somebody said, well, I know what the property is worth. I've seen the ads in the Eagle. And I'm like, well, did you see what they're selling for? Okay, because that's really what they're worth. So this is what this says. And, you cannot cross words out in a contract or an addendum form. So if you were going to use this and you said, it's not presently under contract, but it is listed. Okay, it's listed with me. We would need to cross that out, but you can't do that. So okay.
Can you add two?
Okay.
Like across the bottom?
You can add some words to it because the concept is, rightly or wrongly, this is a blank you can fill in. Okay. But anytime you start adding words, I mean, you're on thin ice, because that's one of the biggest problems I see with contracts is realtors adding words. So filling in the blanks, okay, like this blank right here. I think you could probably do that, because here's the deadline. If the closing on the sale of the buyer's house under the pending contract, remember, doesn't occur before this date, then either party can terminate the contract. But the seller's right to terminate ends when the buyer says, hey, we've closed and dispersed, or the buyer can waive this. Okay? But you put something down here or start wanting to add some language and do some things, that's when you really should get an attorney involved, because not that you guys are goofing it up, but I've seen the ones that goofed up. So I think you need to build a bulletproof approach to how you do these things. And, we close a lot of deals that the contract's incomplete, the blanks are filled in, the realtors wrote something in that makes little sense, but we can make it happen. because 99% of life works out just fine. I think those of you that were in my last seminar, I say, we would buy the car insurance the day before the accident if we knew the accident date was going to happen, but we buy it because we never know that. Same thing happens with your real estate transactions. We don't know when the things are going to go bad, so you need to plan that they're all going to go bad. And then in case one is a problem, it's not. All right? Yes? Well, the significance under Florida law is you can't delete because you're allowed to fill in blanks. And the filling in blanks has been liberally construed to allow bigger blanks than just, what's the date of closing, what's the purchase price. I think at some point you cross over filling in a blank to drafting. And I think that addendum to contract form I showed you that had the big blank page. I personally think you start putting stuff in there, you're drafting. And the sales contract, both FABAR and the NABOR's forms, they have a bunch of those lines at the end just above the signature blocks. I think you're drafting when you start filling those lines in, okay? But you're filling in a blank, so the argument would be, no, you filled in a blank. That's how she probably would address that. And that probably works, okay? But I think you're better off having a form that doesn't have things, because I can't tell you in advance if you put something at the bottom that says the property is currently not under contract, will be listed within 3 days or something like that. I can't tell you that the verbiage that you use, even though that sounds relatively simple, is not going to somehow blow up at some point in the future, okay? Because that's how these things end up in court. There's lots of them that end up in court. I'll give you a great example. And the NABOR sales contract and the FABAR contract had it for years, and NABOR has it now. At the end of the sales contract, there's a listing of all of the amendments and addenda forms, and you're supposed to check the box next to whichever one you've attached, and then there's a line for other. Okay, so if there's something that's not there, and I think we just did one like that where we prepared one that we didn't have a form for, attached it, you're supposed to check the box. Okay, and there's a court case that just came down that said that since you didn't check the box, the form isn't part of the contract. The addendum is not part of the contract. Okay, everybody understands that. So for years we say, make sure you fill in all the blanks, make sure you do all these things. So you don't check the little box on the form, the addendum is not part of the contract. Okay, and what happened in that case was the offer included the addendum. The acceptance went back. The addendum was not part of what was sent back, but the seller signed the contract form. And they ended up in court. This is how things go wrong, you see. 99 out of 100 of those close. I don't know that they close with or without the addendum content, but they close, all right? That one didn't, and it went into trial, and it went to the appellate court, and the appellate court said, you have a contract, but you don't have the addendum. Okay? I think the trial court said you don't have a contract because the offer was not accepted. But the appellate court said, no, you do, because here it was, and it wasn't referenced in there, so it wasn't part of it, and they accepted the part. They accepted the contract, so you've got a deal. Okay. Now, clearly, I don't remember the fact somebody wanted to get out of that deal. It was apparently the buyer that wanted to get out of the deal, but that's what the court said. So here you go. We start changing things, and we don't check the box, and now we've got something that doesn't work. So be careful anytime you're starting a draft, because I think anytime you put something in there, it sounds great when you do it, and doesn't sound so great when it goes to court. And then you not only have an unhappy customer, which is going to send you more business, but you also have the possibility of a malpractice lawsuit. And although you may have E&O coverage, you've got a deductible you've got to eat. And on top of that, then you've got an ethics problem. Okay. And that was a case where I saw where I think the realtor got in trouble for drafting. Not only was that a legal issue, but it was also an ethics problem. Okay. All right. So the seller, last paragraph, seller doesn't have to close fewer than 15 days after the buyer gives notice. So if the buyer gave notice, so that even the time goes by, the buyer still hasn't given notice, either party can terminate. It's kind of like the financing contingency waiver. Now the buyer says, okay, I'm waiving, let's close. Can't do that the day before the scheduled closing. We'll get up to 15 days to close if it's needed by the seller. course, you know, your buyers and sellers always think we can close these deals in a couple of hours. So I have one going on like that right now. Okay. All right. Next form is a survey inspection addendum. Now, this is kind of on top of what's already in the contract. So we've got in the contract right now, the NABOR contract, that the buyer has up until 5 days before the closing to tell the seller about any defects that were disclosed by the seller by the survey, and which means that the buyer has up till 5 days before closing to get a survey done. Those of you that are doing these things for a while know we can't get a survey done the same day you call, but they have to let time. But we might have an issue that we're more concerned with. So this form says the buyer has 15 days after the effective date to obtain a survey to determine the property is the same property visually inspected by the buyer. And if the survey reveals it's not the same property, then the buyer can terminate the contract. So that's when there's some question about where it is. Maybe you're showing them some property that's a bigger unimproved area. Maybe it's out in Golden Gate. Maybe it's someplace else. Maybe it's not even in this area, but this will be allow them. And that would apply to one of the closings I had some years ago. My client called me the next season when he came down, and he said somebody was building a house on his lot. And I initially said, that's great, you get a free house. Then I told him, of course, that wouldn't necessarily be the case. So we found out the realtor had showed him, and he thought he bought a mid-canal lot, and actually he had bought an end of the canal lot. And the realtor showed him the plat and showed him the lot, but the area had been replatted. And under the replat, the number for that lot was not that same number. It moved to the end of the canal, okay? So in that case, he could have done this. I don't think he would have, but he would have had the option to do this to make sure that was the property that was going to buy. Heck, a lot of buyers are too cheap to buy a survey to begin with, okay? So this will be an unusual situation for you. But again, a lot of these forms are for the unusual situation, not for the everyday, this is what we do, or it'd be in the contract itself, okay? All right. This one I see more frequently with cash deals. You know, if the buyer's getting a mortgage, the buyer's got a little bit of comfort, and sometimes they use a mortgage for the reason that they know their bank's going to get an appraisal, going to make sure that the property's worth what they're paying for it. Okay, but with a cash deal, the buyer doesn't have the comfort of the mortgage company ordering an appraisal and being sure that that's okay. So this allows the buyer to get an appraisal, and it says that the contract is contingent for a contingency period of blank days, 15 if left blank, and that allows that time for the buyer to obtain an appraisal by a residential or general appraisal certified under Chapter 475. So that means it has to be a Florida appraiser, okay, showing a value of whatever the number you're going to put in that blank. And that doesn't have to be the purchase price. They may be paying, you know, $1.4 million. They want to be sure it has to appraise for at least $1.3 million. Maybe it has to appraise for $1.5 million. They're buying it for $1.4 million. So that would be up to the buyer, what the buyer wants to put in here. I think you'd have a hard time selling to the seller that has to appraise for more than the sale price in order for the buyer to have a deal, but that's a possibility, okay? And the next paragraph says that if the appraisal states the property does not appraise at least equal to the appraisal contingency price, then the buyer can terminate the contract, and the buyer will get back the buyer's deposit. Buyer has to pay for the appraisal, though. Everybody understands that. So a lot of time when the buyer wants to terminate, the buyer thinks the buyer's supposed to get reimbursed whatever their expenses are, etc. They don't get that, okay? Unless the seller, not later than 5 days following the receipt of the notice and the appraisal, notifies the buyer that the purchase price will be reduced to the appraised value as noted in the appraisal. Okay, everybody understands that? So the seller has the right to keep the deal together by reducing the price if the appraisal comes in lower than the sale price, reducing it to the appraisal price. Okay, this one, we do say time is of the essence. Okay? Okay, this is a backup contract addendum. So this is probably used more when the market was red hot a little bit ago and people were making offers, and everybody enjoy that. We're going to look at all the offers on Friday and see which one we like and let everybody know. I thought that market being hot was going to be wonderful for realtors. And it wasn't bad, but boy, you guys sure got beat up by some folks. Okay, so this is a contract where the seller and the buyer agree that it's a backup contract subject to a previously executed and existing sales contract for the sale of the same property, and it identifies the other buyer, okay? And this contract then is contingent upon termination of that other contract, okay? And if it's terminated, the seller is to promptly give the written notice of termination to the buyer, and upon receipt by the buyer, then this contract becomes primary. And you fill the blank in here that notice, if that's not received by the buyer by 5 p.m. on whatever date you put. So keep that in mind. This says 5 p.m. These aren't all my ideas. This is just the form. 5 p.m. on whatever the date is, okay? Then the buyer can terminate the backup contract by giving notice to the seller. And if no date is inserted, then the buyer may terminate the backup contract anytime prior to receipt that the primary contract was terminated. Okay, everybody gets that? Anybody used this one before? Anybody ever write a backup contract? Okay, this is a good form, right? All right. This is, I want to just be sure you're aware of this. If you're selling a co-op, and I have seen this goofed up by realtors, if you're selling a co-op gives the buyer, new owner, the right to occupy part of the property, and the right accompanied by a share of stock that the buyer is purchasing in the cooperative, okay? So that doesn't really fly into a normal real estate sales contract where we're selling dirt and bricks. So we've got to change the contract around. And I'm going to tell you, going through this in great detail today, you'll probably rapidly forget whatever I tell you about it. But know that you have to attach this addendum to the sales contract because we're now converting from selling real estate to selling a security. The good news is you're okay to sell these. There was a court case that challenged whether realtors could sell co-ops because you were selling a share of stock. Therefore, you had to have a SEC license. And the court said, no, that's really kind of a piece of real estate. Co-ops, by the way, started in New York City at the end of World War II with servicemen coming back from the war and having money from not spending it because they were fighting the war, and the GI Bill, but there was no real estate to buy because kind of like to now, they hadn't been building homes for a while because they were fighting the war instead. And they came back, and our apartment owners in New York said, hey, we can make this happen. We'll turn these into co-ops, and then all these folks can buy a share of stock and they can own a unit. They can occupy a unit in the building. Co-ops got a bad name because the original co-ops had a mortgage on the apartment building, and when enough of those GI came back and quit paying their bills, the whole building got foreclosed, and everybody that did pay their bills lost their units along with the people that weren't paying. Okay? Modern co-ops don't do that. Modern co-ops are standalone, financed separately rather than a bulk financing mortgage on the whole thing. So co-ops aren't scary, but you may have somebody that's heard about problems with co-ops, and if you have, you can tell them that story about how they got a bad name in New York. People come back, but that's not the way these work. You can finance these just like you can a regular real estate purchase. Okay, but we go through this form, and it just goes through, and we fill in the blanks, talking about the fact that this is a co-op. You're buying a share of stock in a corporation. All references in paragraph 4 of the contract to a mortgage mean a security agreement, creating a security interest in the cooperative parcel. Now at the bottom, the seller represents and warrants to any ground lease, and this is something that we do see with a lot of co-ops. They are on ground leases that you have to select one. Either the cooperative property is owned by the association, or if it's not owned by the association, it's held in part by a ground lease. And then we go on to title evidence, and it addresses all the changes that we have to make in a contract in order to address a co-op. So you have to get approval of the cooperative association, et cetera, et cetera. And in connection with Florida statute, right here you see co-ops have the same kind of disclosure that a condominium does. So the buyer is entitled to all the same documents with respect to a cooperative. Okay. I don't want to spend a lot of time on that because if you get a co-op, you fill in a few of the blanks and you've got everything covered. But does anybody have any particular questions on this form? Okay. All right, so this is a form, the addendum to sales contract for up to buyer residential use certificate. Anybody here selling anything owned by a foreign person? No? Don't have any of those anymore? Okay. Are they Chinese buyers? Well, they won their lawsuit. They got a restraining order. Okay, so we got this form, and this form is for the seller and buyer to sign, and it allows a reduced FERP to withholding. As you should know, anytime we've got a non-U.S. person, which is not necessarily just a non-citizen, a green card alien qualifies as being a U.S. for this purpose. So I don't have to fill this out. But if they're a foreign person, we have to withhold 15% of the gross sale price and send that to the IRS. Excuse me. But there are some exceptions, and this form lays out the exceptions. So under 2 is the one that's most pertinent in our market. If the price doesn't exceed $1 million, if it doesn't exceed $300,000, then there's no FERP to withholding at all, as long as the buyer says the buyer is going to use it as a residence primarily for 2 years following closing. And that means that the buyer is going to, or the buyer's immediate family are going to occupy the property at least half of the time that it's occupied. It doesn't mean they're going to be in it 6 months and a day. It means they're going to be in it 2 months if it's going to be occupied for 4 months. So if they're planning on renting it January, February, and March, but the family's going to use it in the summer and in the fall, maybe come down for Christmas, and their intent is that they're going to use it at least 50% of the time that it's in use, they qualify. Okay, and that's important because buyers get antsy about this. They say, well, I'm not going to use it half the year, and we're all going to rent it. And as long as they're planning on using it, and it's a question of intent. It's a question of intent. It's not a question of do they actually do it. It's a question, do they tend to do it. Okay, now if immediately after the closing they list the property for rental on an annual basis, the IRS takes a look at it. I think they have a problem. Okay, but y'all won't because you didn't know anything about that. Okay, so this is the form you can get them to fill out, and some savvy foreign sellers will insist this be part of the sales contract because they want the reduced withholding. We used to see a lot more of that when our properties were under $300,000 because there was no withholding at all. If they go to the million, the withholding is reduced from 15% to 10%. So there's still sellers that want to have this signed. So if they're talking about it, this is a form. You don't have to go get it drafted. We've done that. We've done the handiwork. So if the parties will sign it, it'll work out and be fine. And again, from a buyer's perspective, this is down at the bottom. We say buyer's advised to consult a legal and or tax professional because they do get antsy about signing something and they think they're going to get in trouble with the IRS. So, okay. Addendum to sales contract, homeowner documents review. This is not required by Florida statutes. Okay, I want to make this clear. Florida statutes only gives buyers in a condominium or a co-op the right to review documents and back out of a transaction if they're unhappy with the documents. Okay, they have a 3-day right of review. There is no comparable right for homeowners associations. The right for homeowner association under the statute is the buyer has 3 days to review the homeowner association disclosure summary, which tells the buyer what the costs are of owning a property in that particular homeowner association. What are the assessments? Okay, you're familiar with that form. So this says, okay, the contract is now going to be contingent on the buyer getting, at the seller expense, current copies of the covenants, the conditions, restrictions, articles of incorporation, bylaws, rules and regulations, and most recent year-end financial statement from the homeowners association. Okay, just want to make you sure you understand this is not required by law. Okay, but some of your buyers will want to use it. When might you want to use it? Anybody have any idea when a realtor will want to use this form? Okay, you're going to tell me never because it gives the buyer 3 days to back out of a deal. Okay, but
because you got outdated financials. Okay, you're not going to sign the. You know what I mean?
There's something at question. You would use that.
okay, so when would it be a time to maybe use this form? When you've got an HOA, because what do we hear when things go awry is that the seller was hiding things from me, the buyer, the realtor was sneaky, they knew I'd be unhappy if I knew I couldn't have a red door or I couldn't have a ham radio antenna or whatever it might be. So if the contract makes it contingent on getting these documents and they get to the buyer, then the buyer is hard-pressed to argue that there was some concealment of something that was there, right? Okay, so something to think about. course, the sad news for a contract is it gives the buyer the same 3 days to terminate the contract that the buyer would have had under the co-op or the condominium disclosure.
Basically, I conduct my slip sales too.
Okay?
I don't know if technically I'm doing the right thing, but I believe that the buyer should have a review period to go over all the Marina Association documents. Not this form, but the other form.
Well, the trend around the country is for buyers to have time to review and think things over. I can tell you that. It hasn't filtered into Florida yet. But the trend around the country is that buyers get time to think about whether they really do want to buy whatever it is they've signed up to buy.
So would it be wrong of me for marking up the, normally people don't care. I use the Homeowners Association document review sheet or form. And I've had, like, a lady the other day asked me to cross out Homeowners Association because it's a Marina Association. So of course I did. That doesn't.
You're not going to cross anything out again. You're going to get your customer to do that because you can't cross anything out. But if they do that, you can do that. But that's an example of where this form could be modified, but not by a realtor, to cross things out to apply to the Marina Association if you're selling a boat slip, which was what some unnamed person mentioned. So if you're going to be doing that, for a boat slip, I think you're okay. For a boat slip, I think you're okay if you're using this for a boat slip. Okay, but no. Okay, because a boat slip's not residential properties we talk about, so that the 3-day right of rescission applies to a cooperative that's residential and to a condominium which is residential. Okay, so we get there and we get these disclosures. So this works though. This works well, and I think it works well for some people who really want to have this, transparency. Everything's clear and open and above board. And we're going to do this. Now, would a seller push back on this? Okay, I could see a seller saying, "Hey, I don't want to give a buyer 3 days to back out of the deal. You want to check things out, check them out, and then come back and sign a contract with me. But don't sign a contract now, because if the buyer comes in here tomorrow, it's going to pay me $100,000 more than you're going to pay me. I don't want to be stuck with you waiting to see if you're going to follow through on the deal." Okay? So just be aware that if you do this, I think some sellers are going to push back. Okay? And some sellers with attorneys, the attorney will say, "Oh, well, look, this isn't required by law. You don't have to sign this." It may create issues. So always be, you got to look at both sides of the fence. But I like this form because it does do that. And some buyers say, "How do I get this information?" Well, if you didn't know before, you now know that you can't get this information as a matter of right under Florida statutes, but you can get it as a matter of contract. Okay? Okay, I've seen this. You're selling property. As you know, there's some certain properties that qualify to be housing for older persons. So the next addendum is addendum to sales contract, housing for older persons for 55 plus occupancy, because there's 2 categories for that. And this says that the seller has disclosed, the buyer acknowledges the property qualifies as housing for older persons under the Housing for Older Persons Act of 1995, and that at least one person who is 55 or older must occupy the property. And then it goes on to say that the seller and buyer are relying on this form. So this helps get you off the hook, because there are a number of properties out there that do not actually qualify as 55 and over communities, but they think that they do, and therefore they masquerade as being 55 and over communities. So if you tell people that it's a 55 and over, and that's what they're buying into, they don't want to be in a place with young people. So they want to move in there, people that are their own age, they can enjoy their company, and they find out that, in fact, this place is not telling the truth. It's a violation of the Fair Housing Act for that particular condominium homeowner association to say we're 55 and over, you can't have kids because you got to be 55 and over. Okay, well, they've just disqualified children and families with children. That would be a lawsuit under the Fair Housing Act, and your customer won't be buying into that if it's not true. Okay, so we're relying here on the seller making the representation that it's a 55 and over community. The other reason to use this is because you don't want to be entering a contract for your buyer to later find out that since your couple that you're representing are in their 30s and they're buying this place to use later and to rent it, they can't even own it because one of them's not 55 years of age. Okay, so any questions about this one? Yes, sir.
You have a copy of the affidavit that you would have the representative of the community sign, fill out, or you just have you fill one out?
Yeah. Okay. Okay, so we move on. Excuse me, I gotta get back here. Okay, this addendum to sales contract, lead-based paint and/or lead-based paint hazards. Now, this would be a form that you'd be using with a pre-1978 home because this is only required, and the disclosures are only required under federal law pre-1978. I don't know exactly the date they quit allowing lead paint to be sold and used, but the Fed law says we're pretty comfortable that anything built prior to 78 might be affected, but anything after that is not going to be. So we use this form. You don't have to use it unless you're using one of those older homes. And at least in our market, I find most of those really old houses, people are buying to tear them down. So as a practical matter, it's not going to be an issue anyway to your buyer. But this requires that the seller disclose what the property is that we're talking about. And number one, at the presence of lead-based paint hazards, and then either the seller knows that he's got it or the seller has no knowledge. Anybody here ever get a seller disclosure form filled out? No? Y'all doing this real estate thing for a while, right? How many of those customers fill in don't know?
All of them.
Is the water, the city, or the county, or a well? Don't know. Who's the electric? Don't know. You know, the roof still on the house? Don't know. Okay, I love those. I read them. And then the other hand, I see the other ones that are they fill out everything. They tell you the life story that they replaced the flooring, they put this in, that they bought a new refrigerator last week. You know, it's all in the disclosure form, and you're like wearing out reading it. So, but one of my warnings on the disclosure forms is read them when you give them to your customer, because there can be things in that disclosure form that you need to be worried about, and if you don't help your customer see them, then the argument is you've defrauded them, you've concealed things, et cetera, okay? So we got to tell the seller whether or not, the buyer, whether or not the seller knows anything about lead-based paint, and then records and reports, the seller's provided any or the seller has none. And then down in this section here, B, buyer received copies of everything listed above, received the pamphlet. This is a federal pamphlet that's available on the NABOR website, and also I believe where your other forms can be obtained. And the buyer has either A, received at least a 10-day opportunity or other mutually agreed period to conduct a risk assessment, or waives it. Okay. And then we go through that the buyer received the attachment or comparable disclosures at any time after the effective date. Then they have up to 10 days after the effective date to determine whether or not they're going to proceed. Okay, so you want to give them that at the time they sign the contract. All right, this is addendum to contract. Got to get back there. Lease back by seller. Okay, this is a good form, and again, it's an example of how realtors filling in the blank lines on the bottom of the contract might not get the job done. This form might do a little better job. I've seen some of these contracts that we've closed, and in those blank lines at the bottom of the contract says, seller to lease back property for $5,000 a month for 90 days. Okay, that's terrific, but what else is the seller going to do? So here we've got a form that talks about what's going to happen on the lease back. The rent is X per month plus sales tax if applicable, and keep in mind that anytime there's less than a 6-month lease, there's a sales tax involved. Okay. We got down here then who's going to pay what? Association maintenance, basic cable, telephone, contents insurance, electric, hazard insurance, lawn maintenance. So we go down this laundry list. Other. These are the things that people tend to forget putting onto the contract when they just put it's going to be a lease back, seller's going to lease it back for X amount per month. We at least try to address these things, okay? And then up here it says that they're going to lease it for X months under the terms of a written lease agreement to be prepared and delivered to the seller by the buyer or the buyer's attorney not later than 15 days after the effective date. And if the seller does not approve the form and the terms, by initially and returning a copy of it to the buyer, not later than 5 days after receipt, then the buyer can terminate the contract. Okay, so this is a lot more work than just putting down the seller's going to lease back, but it gets a lot more of the job done, so we can agree on who's paying what. Because when they're leasing it back, if the seller's going to lease it back, it's going to pay these numbers. At least the parties understand that. But the ones that I have that fall apart, that blow up, are the ones we get down at the closing and we don't have a lease, or we get the contract in, we don't have much time, we draft the lease, we send it over, and then they start arguing about who's going to pay for this, who's going to pay for that, who's paying for the lawn and pool maintenance. Who's going to pay for the bug killer to come in every once in a while? Who's paying for maintenance? Who's going to pay for the air conditioner if it breaks? What's going to happen? So this is a really good form. If you're going to do a lease back, and I've seen more of those the past few years than I used to. So we've got a lot of things. People either want to close in May, or they're going to close earlier and the seller can lease back and stay because the seller wants to stay through season. So this is a form. Any questions on this form? This is one I think you should remember.
You just put a lease with it.
Well, we could put a lease with it, but here's the rub with that. If we just put a lease with the offer, does the buyer want to pay an attorney to draft a lease before the buyer has a contract with the seller? Maybe your buyer will. Most buyers won't. I mean, I've got, as you all have heard my stories, I've got buyers that buy millions of dollars of property. They're too cheap to buy a survey because they figured they don't need a survey because the property's already built or whatever reason. And the main reason is they don't want to spend for a survey. So I'm real sure they're not going to want to pay for a lease, and we just can't pull a lease off of. You could go use that Florida Supreme Court approved form that you guys can use as a lease. Anybody looked at that? It's confusing to me. So it's a tough form to use. So if you want to put that in there, say here's going to be the terms of it. You do have the ability to fill the blanks out on that form, and you could include that as part of the contract offer. Okay. But the typical realtor is going to struggle through that form. I can tell you that. So here's an opportunity that we could set this up, see if it's going to work, and if it works, good. We could prepare the lease. We could prepare the lease later and see if it still works. Okay. Right.
Are you saying that is the lease?
No, this is not the lease. We have to prepare a lease. This just says here's the highlights of mostly the financial terms and the length of time that the seller is going to lease it back. Well, it's, these are the pointed out there's no deposit, no cleaning fee. So I mean, this isn't an effort to draft a lease. So there's lots of stuff here that still needs to be negotiated, and you put a deposit or cleaning fee, here at other. So it's still pretty bare bones, but it is a whole lot better than just the language that I see on some of these contracts. This is seller to lease back $5,000 a month or whatever the number might be. Okay. And if we did that, it's seller lease back, buyer to pay all expenses except for this is the $5,000 a month lease. Then they'll argue about who's going to pay the sales tax. Okay. Well, they might not. Okay, they might not. But I got.
They just increase the offer amount and put 0.
You could do all kinds of stuff. You could increase the offer amount, put 0 for the lease, just give them the right. But then I think you'd want to enter the post occupancy addendum rather than this. Okay, so we've got these issues though, and remember this says here's who's going to pay what. So is the person going to pay for any of these expenses or not? If they're not going to pay any of them, then you can just put seller to retain occupancy and use the post occupancy addendum. Okay. All right. This would imply a little bit longer of a term. Usually the post occupancy addendum is for a relatively short period of time, maybe for it's 30 days, 2 weeks, whatever it might be. So I think that implies that we're going to be a little bit longer. Okay, addendum to sales contract, personal property inventory. Okay, now the sales contract itself says that if personal property is included and inventory is attached. Anybody here have a deal where there's no inventory to attach? No, you always go and the listing agent has got an inventory, right? Okay, maybe not. So in those deals where there's no inventory, but the buyer wants to be sure that everything is that whatever they're getting, and there's still even some confusion about what the buyer's getting. I had a deal. I have lots of deals that have been a lot of fun where the seller was going to keep the seller a few personal items. Turned out about half of the 2/3 of the condominium were personal items. Everything from the cushions on the sofa that were hand crocheted by the niece, and we went through this whole thing. We got it resolved, but I think the buyer's idea of a few personal items and the seller's idea of a few personal items certainly would conflict in that case. So here we've got that the contract is contingent upon the seller delivering the buyer within 5 days of the effective date an inventory of the personal property and the buyer approval of the inventory not later than 2 days after receipt. Okay? And the buyer could terminate the contract not later than 10 days after the effective date if the seller fails to deliver the inventory, or not later than 2 days after the buyer gets the inventory if the buyer's unhappy with the inventory. So if the inventory is driving the ship, you can use this form. Now I see a lot of people shortcutting. Instead of doing an inventory, they'll write up and say as furnished on such and such a date, and then they take lots of pictures, and then we have all the furnishings that are in there on that date. I don't know how detailed they get. I haven't seen any of those yet where they open the drawers to see what's in the drawers and the linens and these kinds of things. So there is a shortcut, not quite as good, and I know that the inventories are tough. We do have an inventory form in the NABOR forms directory, and those of you who work in brokerage firms that have rental departments, they have inventory forms as well, and they are a little painstaking to fill out. But this would be something where at least if they agree on it, we're not going to be arguing later on, hopefully, about what's there. Okay. And then the paragraph here says the price offered by the buyer and accepted by the seller is intended to reflect only the value of the real property. So we still try to pretend like there's no value on the furniture so that these folks can go get financing. And I think this one may or may not be problematic for financing. So if you've got a finance transaction, you might, and I would highly recommend you consider that you use a separate personal property sales contract, and we not have an addendum referencing personal property. We do it all completely separate. We put a reasonable number on the furniture, and then they pay the furniture closing, and then we close the real estate deal under what they're paying for the real estate. Okay. All right. I think that's it. I think I'm done with that one, huh? Okay. All right, so we were talking about post-occupancy closing, so we've got a pre-oc. So I just want you to take a look at this form to start with. Does this look anything at all like what you think a realtor would fill in on the blank line saying that the buyer can occupy the property on Tuesday until closing? I haven't seen too much of that because we're aware that this form exists. So let's just go through this form and why it's superior. Okay, so this talks about that the buyer can occupy the property prior to closing, commencing on whatever the date is, and pays the seller an occupancy fee of blank for the period from the date of occupancy through and including the closing date. Buyer pays additional fees of blank per diem if closing occurs later than the closing date through no fault of the seller. Okay, now we're trying to pretend that's not rent because
just like if the buyer wants to come a week early before closing and get in the house.
a lot of them want to. Okay, I hate to let them in early, but there's sometimes a reason why they should be in. Okay, and it's because everybody's agreed they're going to be there, and there's been some kind of a hang-up. I see this even, it says amendment, so you see this, usually it's after contract. Remember, if you amend the contract, I just want to warn you, technically, the buyer's supposed to give that amendment to the lender because it's part of the contract. So if we're going to do this, we're going to submit something, and we're going to then have to submit this to the lender. I'm going to tell you, that could be problematic. But this is something that, where this comes up a lot, is the buyer wants to move in, but their money's not ready. Okay, it's going to be ready. And I've had this happen. Sometimes it doesn't work out. I had this happen where the buyer is getting a huge bonus. I actually had one where they didn't get the bonus. Okay, but they were supposed to. I can't remember exactly why they didn't get the bonus, but it was all good, and it was a big bonus. I mean, you're talking hundreds of thousands of dollars that the buyer was going to get as a bonus for whatever they did in the employment they had. And it didn't work out. So this was a situation where that got delayed. They wanted to do it. So this is when they used. The buyer moved in, and that's why I remember it so well, because now we're having to fight over it. The buyer's in. Buyer's not getting the bonus, and what are we going to do? Okay. So in any event, though, this says it's not rent. It's an occupancy fee, and we do that so we don't have to collect sales tax and remit that and go through all that Department of Revenue filings. It's a little bit of a weak argument, but at least it says it's not rent. So the parties agree the pre-closing occupancy is not a lease, and the occupancy fees are not rent, and this is why we do all that. Okay. Now, here's what happens when the buyer moves in. Buyer accepts the property as is at the time the buyer moves in, right? Okay, so now the seller's obligations to keep it in shape, repair it, take care of it, end, and the buyer moves in. And the contract itself says that the buyer's obligations to take care of the property start at the earlier of closing or occupancy, and the seller's end. Okay? And then here, the buyer waives any and all of buyer's remaining contract contingencies and all remedial action obligations of the seller or credits. Occupancy is limited to blank persons and the following pets. Okay, now what this does, and you have to be aware of that, is the seller is now off the hook completely. Right? You're moving in as is. What if the contract requires the seller to put on a new roof?
They don't have to.
Not under this amendment, that's right. So you need to be really careful with what this form says. So if you've got anything other than just a regular Manila deal, and maybe even then you ought to get the lawyer to look at this thing, because this would place the buyer in a very strong arguing position, if not winning argument, that the seller, no longer is going to fix the roof, no longer put the roof on. Seller's happy with this deal. I'll let you move in early. You could pay me nothing. I'm a nice person, because it's going to cost me $100,000 to put a new roof on, and I don't want to do that. And this says I'm off the hook. Okay? So be really careful with that. I haven't had that be a problem, but I see it as a possibility. So this is a time bomb for you guys. Okay? Okay? It says down here, though, the buyer can't make any changes. During the buyer's occupancy, the buyer is responsible for utilities and shall obtain liability insurance and insurance coverage for the buyer's property. So that's the buyer's property. The buyer doesn't own the house yet. The buyer doesn't own the furniture if it's being sold furnished. So the seller needs to keep the seller's insurance on the property if the seller wants insurance. So don't tell your seller, okay, you're off the hook because this says you're off the hook. Cancel your insurance. Don't sweat it. No, they got to keep their insurance, right? Because it burns down. Okay, going to be a problem, okay? And that if it doesn't close by the scheduled date through no fault of the seller, so the buyer's reason that it doesn't close, it could be the buyer's financing, could be my boy that didn't get his bonus, could be anything like that. It's not the seller's fault, right? Seller give the buyer 5 days written notice to vacate, and the buyer has to leave the property in the same condition it was in when the buyer moved in. The buyer does not vacate, then the buyer's per diem, and we had this up here, doubles from the date buyer receives notice until the date buyer vacates. Buyer agrees seller will be entitled to recover unpaid occupancy fees and any cost to repair or clean, and costs of collection these sums from the buyer, including attorney's fees. So, will the seller sue the buyer? I haven't seen one of these happen, so the good news is I can't tell you. But, boy, the parties sure get interested in lawsuits when they think they'll get their attorney's fees paid by the other side. Okay? Yes?
During that time period, 5 days, whatever, 30 days, what's the situation as far as insurance? Property itself can't be insured by the buyer.
That's correct. The seller has to maintain the seller's, the seller doesn't have to keep the seller's insurance on there. It's like the seller doesn't have any insurance ever, unless the lender requires it, and even then the seller can terminate their insurance and the lender go out and force place it. Well, the buyer can insure the buyer's property, and this says the buyer is supposed to, is responsible for insuring the buyer's own property, okay? So the buyer can do that, but what's the buyer got? 90% of our stuff or more sells furnished. So the buyer moves in, the buyer's got the buyer's clothes, whatever stuff the buyer has got in the garage, I guess, buyer's car. So there's probably not a lot of things for the buyer to insure when the buyer's in the property before closing. Of course, immediately upon closing, it's the buyer's problem to have insurance because now the buyer owns it. Okay. Now you're right, the buyer can't get insurance. So if we try to write this up and say, well, seller will let the buyer occupy, but the seller, wants the buyer to get insurance on the real estate, buyers are going to have a real hard time doing that. There might be some kind of a tenant policy out there, but we just said this isn't a rental. So I just haven't seen that to be something that really works out well. So be sure your seller knows the seller has to keep their insurances on the property, okay? Okay. This is the addendum to sales contract, right to inspect and right to terminate. This one I like. In this market today, I hear more than 80% of your buyers find the property they want to buy online and then they contact a realtor. Does that sound right? Or is that my figure's still about right? Okay, so now they've seen it online, or you send them pictures or both, right? Because you do that too, right? They contact you and say, hey, I saw this property. It's over in Fiddler's Creek. I really like it. And you go, oh, well, I'll go out and preview it for you. And send them all the pictures or whatever you can do. Well, this says here that the buyer says, now I want to fly down this weekend and I want to see it. Anybody ever have that happen? Okay.
In an as-is contract, you already have that. Would you do this and attach it to an as-is contract?
Well, you wouldn't need to with an as-is contract, okay? But with the other contract, you don't have that, so you've got an obligation to close. So we've got here, within the inspection period, now the inspection period, as you know, is 15 days in the standard residential contract. So within 15 days, right, the buyer determines that the property is not suitable for any reason or no reason, then the buyer can terminate the contract. So this is something that you can look at, and I'm not, doing your job as a salesperson, but Here you have something, if you have an as-is contract and you go to the seller and say, okay, the buyer can terminate the contract anytime they want to for any reason at all. They can do it for inspections. They can do it because they don't like it. They have whatever number of days that are in this as-is contract. Use an as-is right to inspect NABOR sales contract form, right? It's not an as-is sales contract. It's a, I get to look at it, decide if I really want to buy it contract, okay? So it's really an option contract. The only difference is the seller doesn't have to even respond to a buyer's request for repairs, and the buyer doesn't have to use a licensed inspector or repair person to do any inspections the buyer wants to do. The buyer doesn't have to do any inspections at all. Okay, so we've got that. I've got that thing, and I've got the seller looking at that. I'm going, okay, I've got that. I'm not too keen on signing a contract that the buyer can get out of any time they want to. Might this be an easier product to sell to a seller that says, these guys saw it, they love it, they want to sign a contract with you, they're coming down this weekend, they want you to agree it. Before they fly down, they want to know they got a deal, and then they're going to fly down. They're going to get on a jet and come down here. That's just a different approach on how you can sell the product. I'm telling you, you do it as you like. But to me, okay, to me, it's a much easier sell to a seller to say, hey, we got a deal, they just want to come down and look at it in person, because everybody can relate to that, I think. I buy cars online, but everybody else likes to go look at the car before they get it. Okay, and as Kelly points out, you got a buyer, you talk to your buyer and say, hey, we can get the deal, but you guys can come down here and take a look at it to make sure it still looks as good, because we have heard the stories, pictures don't quite look the way the thing looks in the real world, right? I get those complaints, right? I came down and, God, the thing doesn't look at all like the pictures, you know. Once I got to see it, the carpet looks like heck, the cabinets are horrible, you know. So this is, I like this because I think it gives you another bite at the apple of how you put the deal together, okay? And in a lot of cases, it's the real thing under this market right now. They look at it, they see the pictures, they don't want to come down unless they know they got a deal, they know what the price is. And although y'all do a lot of telephone arrangements and contract negotiatings without having it in writing, this lets, okay, we got a real deal, they'll come down. And at least one of you says that buyers are now willing to come down because they have a deal, okay? All right. Okay, this is, next form is the addendum to sales contract post-closing occupancy. I'm going to just kind of go through this real quick. This is the converse of the buyer gets to move in early. This is the seller gets to stay late, okay? I do not like post-closing occupancy. I do not like pre-closing occupancy. I think that they are ticking time bombs just waiting for something to go wrong. The pool filters always, motors always break down. Air conditioners explode. Hot water heaters leak. You know, things go wrong. But I had a couple of deals a few years ago which I really thought post-closing occupancy was appropriate. And both of those deals, the seller was very elderly and frail, and they really wanted to be sure that they closed before they moved out of their primary home. They didn't have any other home, and they wanted to be sure that was the deal. And they weren't even going to go. They were very conservative. They didn't have a lot. The market's changing, but they didn't have a lot. They didn't want to even go shopping for another home because they wanted to make sure they had the money from their sale to go shopping. Okay, so I think they had like a 15-day move-out time, and that's one of the few times that I thought that was a pretty good idea under the circumstances. But other than that, I just abhor these pre and post arrangements because they're just waiting to go wrong, you know. But this is just the converse, and it allows basically everything in reverse. So I just want to let you know it's there. Okay, this is addendum to sales contract seller financing. So I'll go through this with you. Are we seeing much seller financing? I didn't think so. Okay, as you probably know, for your purposes, the only seller financing that really we're going to be involved with is going to be if it's owned by an individual or couple, an estate, or a trust. Okay, and it's a residence, and they can do one a year. They can sell it and finance it. Everybody understands that. So those are, for your purposes under Dodd-Frank, the people that can do seller financing if they're going to. Okay, so we start by saying, hey, go talk to a lawyer. Dodd-Frank has some limitations on what you can or can't do, and we think you should talk to a lawyer. And remember, these contracts are drafted by a trade association committee, so that, although that's good stuff to tell the parties that they ought to talk to a lawyer, it also gets you off the hook, because as I always say, especially after going through a lot of ethics hearings, that the get out of jail free card for a realtor in most ethics hearings is, I told these folks to talk to the attorney. I didn't give them legal advice. I told them to talk to an attorney. If they're talking to the attorney or and they've hired an attorney, that pretty much gets you off the hook because now they've got an attorney. So the drawback to the title company is you can't then go to an ethics hearing and say, I told them to use the title company and they relied on the title company for advice. So there's a myriad of cases, reported cases, where the realtor is off the hook because the customer is complaining, but the realtor says, well, I told them to go to a lawyer and they did. Or I told them to go to a lawyer and they didn't. So keep that in mind. But here's the language, again, to keep you guys off the hook and to make sure these folks try to get some good advice. Then it says either the seller or the buyer can terminate the contract by giving notice of termination not later than 10 days after the effective date. If the seller and or the financing described herein does not comply with Dodd-Frank, the Act, or fall within one of the exclusions in paragraph 8 below, and we'll get to that in a section that tells you who can finance. This is a big deal if you're doing seller financing, and I think it's important that you make sure the parties know about it, because the buyer doesn't know about this paragraph most of the time when I see this. And then when they start asking for things, they're unhappy to find out their time for asking has expired. Within 5 days after the effective date, the buyer is to furnish such credit, financial, employment, other information about the buyer as reasonably required by the seller to evaluate the buyer's creditworthiness. So the seller can ask for that. If the seller doesn't ask for it, the seller doesn't have to get it. The buyer doesn't have to provide anything, okay? Then the seller has 5 days after the seller gets that to tell the buyer whether the seller is going to finance the deal or not. Okay, anybody here ever have a deal that when you're just prior to closing and the seller decides, now I'm going to ask for credit reports, things like that? I've had those. And we go and we ask and we're told no, and I have to go back and tell the seller we can't get it. Okay? Right? And at closing, this tells what happens. The buyer executes and delivers the seller a negotiable promissory note payable to the seller. It's the amount of the seller financing. With the money, it's either going to be a first or a second mortgage, so it depends on the transaction, right? In the same amount, encumbering the property, and that property is a defined term. That's the property that's being acquired, right? To secure repayment, the mortgage is a second. A default on the terms of the first shall, at the option of the holder, constitute a default under this mortgage. And then it talks about the interest rate per year or amortized term of not fewer than blank years, and if there's going to be a balloon, okay, or no balloon feature, okay? And it says the buyer will be personally liable on the note. So if the contract starts out in the individual's name and they want to put an LLC, the buyer is still going to be personally liable, okay? Then the next page goes on and it describes the financing. Are they going to be monthly, quarterly, semi-annual, or annual payments? Is it going to include principal and interest or just be interest only? Okay, and the late charge is 5%, not made within 10 days. So this kind of addresses most of the terms of the mortgage that the people want to complain about, okay? Okay, the note and the mortgage are to be prepared by the buyer and given to the seller at least 15 days within 15 days after the effective date of the contract, and contain terms and conditions that are customary in mortgages in this market, okay? So it also goes through a due on sale clause. So we go through this, everything that's supposed to be in there, and this, we hope, avoids too much argument about the mortgage and its contents and the note, okay? Then down here are the exclusions under Dodd-Frank. We can go through those, but for your purposes, there's a 3-property exclusion. It's more complicated. So if you get anything at all, if you're going to use a title company and you got this thing with 3 properties, use an attorney. But if at least you got the seller is the trust, the estate, or the individual, then you can do 1 per year. It doesn't have to be a primary residence. Okay, it cannot be a build to sell, so it can't be the seller built it to sell it, but it can be 1 house per year. Okay. Okay. Addendum to contract, short sale. Are we having any short sales? I have noted an uptick in condominium owners not paying their assessments and going into foreclosure. Anybody else seen that? Okay, it's shocking to me. And I talked to some other people too, and clerk of courts even. They're just shocked. I mean, why would they all have equity? How can that happen? So, well, for timeshares, I'm talking about reasonably good condominiums, none of which am I aware of are under distress or damaged in any way. So you can't answer any of my questions. Thanks a lot, guys.
Sorry.
All right. So I actually was hoping I'd get an answer on that one because I am curious because there's nothing about that makes any sense to me. All right, so we've got the addendum to contract, short sale. Just to remind you that the short sale is an arrangement under which the mortgage holder agrees to take a haircut and not get paid in full and allow the property to be sold. I don't think we see that happening these days because we don't have that same mortgage market. But if we ever get back to that market, we've got a form for that. Okay. This one is something that you might be interested in. Over the years, developers have gotten a lot harder to deal with on these things. We did for a while, especially back in the 90s, had people that would buy a developer product and it wasn't going to come online for 2 years, and they would buy it, and then during that 2 years they would sell it to somebody else and make a profit on it. Okay, and the developers really got unhappy with that because they wanted to make that profit themselves. So in some cases they were competing with the developer. So it's hard to make those things happen. So rather than be able to sign or flip those contracts, which is what we did originally, now let's say you can't flip them. But what you might be able to do is make an arrangement under which the second buyer buys the property from the first buyer. But you can't buy it because the first buyer doesn't own it until they buy it from the developer. Yes? Okay. The problem when you write that up is the transaction always was intending to use the second buyer's money to acquire title in the name of the first buyer so the first buyer could then convey it immediately to the second buyer. Everybody understand what I'm talking about? Okay. And when people put those deals together, they kind of forgot that they had to make something in a contract that would allow the first buyer to use the second buyer's money to acquire title before the buyer had title. Okay? So that's the key to this. And I'm telling you that because back, I guess, late 80s, early 90s, and I was working with developers in Lely, and I was doing some of these. I think I was the only one that was writing them up so that we did them right. And over time, we developed a form so that you can all do them right. Okay? So this is the addendum. Talks about that the seller buyer understand and acknowledge that the closing contemplated by the contract will occur simultaneously with seller's purchase of the property from the developer, and the contract must be entered into only after careful consideration by the parties and review of legal counsel. That part's important. You need to understand a lot of those developers now have deals that you can't even sell the property for a year after you buy it. They did that to get rid of this as well, okay? But a lot of them don't. So this is the one you need to use if you're going to do that, okay? Either seller or buyer may terminate the contract following review by legal counsel by notifying the other party of such termination not later than 10 days or whatever you put in the blank after the effective date. So that gives your people the right to go ahead and sign a contract and then talk it over with their lawyer. You're writing it on Saturday, and they get to look at it, okay? Seller represents and buyer acknowledges seller does not currently own the property. That's something that's important to disclose because the second buyer will come in and complain that nobody told him the first buyer was under contract to buy, okay? It's under contract to purchase it from the developer under a contract dated, and that the seller further represents the buyer the developer contract does not prohibit or otherwise restrict the simultaneous sale. Now, I will tell you that this isn't really quite right. We can't do a simultaneous closing unless we're involved with two different properties, right? Because this really has to be an almost simultaneous closing because we have to close the buyer from the developer, and then instantly after that, the buyer to the second buyer. And that's not simultaneous. It might look like it, but it's not, okay? But I just want you to be aware that those two things have to happen. So when we do one of these deals, we're not only searching the title to make sure the title looks okay, what we're going to do, and watching what's happening with the first buyer, we got to search the first buyer. Make sure that the first buyer doesn't have judgments out there that as soon as the buyer takes title, those judgments attached, and then they convey it instant later along with those judgments, okay? So it's an important thing to remember, but we do that as part of the closing, okay? Okay, now here we talk about not later than 3 days after the effective date, the seller will give the buyer a complete copy of the developer contract. Well, remember, we got 10 days here to look it over with our attorney, so don't make that too short. 3 days after the effective date for the seller to give the buyer a complete copy of the developer contract. So if you put 2 days here, the seller doesn't have to give the developer contract for 3 days, and that can have things in there, like what's going to be done and what the rights are to change. This isn't perfect. If you're still early enough in the program, we're going to get to number 4. I'll show you some of the issues. You need to be sure the parties sound like they're going to cooperate. Okay, Closing date scheduled by the developer under the developer contract. The seller will give the buyer not fewer than 7 days notice of the scheduled closing date. That's because those developer sales contracts often have as short as 7 days to close. I see most of them are like 10. And that's one of the things I circle and I give to my client when I'm looking at those. I go, are you going to be okay with this much time to close? I don't know. You want to fly down and make sure it's okay. What are you going to do? Is your money available? So be careful with that. Purchase price includes any sums prepaid by the seller for upgrades, extras, and options. And the buyer acknowledges the buyer is not bound by and will accept any such upgrades, extras, and options, and any color flooring. So whatever the seller has picked out, the buyer is going to agree with. Then it gives the buyer the right to exercise the seller's option selections. But if the buyer fails to exercise the selections within 5 days after offered by the seller can make the selections and the buyer's stuck with that. Okay, so this is an important paragraph because that's often left out when realtors write up their own simultaneous deals. We forget about the seller and the buyer. There still may be things to pick: paint color, carpeting, cabinets, I don't know, whatever they pick in those things. So be careful with that one. Okay. This requires the seller, number 5, to promptly give the buyer copies of all correspondence and communications that the buyer gets, including a title commitment, survey, certificate of occupancy, whatever the buyer gets from the developer, the seller is supposed to send over to the buyer. And to the extent permitted by the developer, the buyer shall be entitled to participate in the seller's walkthrough and help do that. The buyer acknowledges that all or a portion of buyer's closing funds may be used by seller to purchase the property from the developer. Buyer shall tender buyer's closing funds to the closing agent designated by buyer not later than 1 business day prior to closing. And that's because it's just what we talked about. They're going to use the second buyer's money to acquire title, and the 1 day prior to closing is so the money's there. Okay. I haven't had a wire go bad in years, but I've had a few that, they couldn't find them. They had to go look for them, and you have to do that from the sending end. I can't tell you where something is I didn't get. So I'm always afraid we're going to have a problem. So I tell our clients, send your money to me the day before. I don't want it earlier than that, but that gives us at least a day to go figure out what went wrong. Okay. Okay, 9, at closing, the seller is going to give to the buyer all assignable developer, contractor, manufacturer warranties. Okay. At number 8, not later than 3 days prior to closing, the seller is going to execute all seller documents necessary and customary to sell and convey the property. And in addition, the seller documents that convey to the buyer the exclusive right to use parking spaces, storage spaces, et cetera, et cetera, et cetera. So that way we get everything at least 3 days before the closing. The seller, and you know that we can sign those things before the seller actually owns the property. Okay? If the contract is subject to a buyer financing contingency, and if buyer's lender does not approve the simultaneous closing, buyer may terminate. I don't know any lenders that approve this deal, so you know. Any questions on that? Anybody else know a lender that'll approve this deal? Okay, we'll go through this one pretty quick because we don't see much of this in this market. VA, FHA financing. Anybody here sold a property with VA or FHA financing? Okay. They're not really complicated, but there are some requirements under the FHA and the VA financing. So we check the boxes, and the primary one, as you'll see here, in the FHA financing is the property has to appraise according to the FHA at no less than whatever the number might be. Okay, so we put in there the sale price. And these are requirements because these are things that allow the buyer to get out of the deal if the things don't work and require the seller to cooperate. So because we do so few of these, I'm just going to tell you that it exists. The contract itself says if you're FHA or VA financing, you have to attach this. So you know it exists. And as I said, it's called addendum. So it's easy to find. It's a sales contract. Okay, VA, FHA financing. Okay. Visual inspection, property by the buyer. I think we already have that in there. It showed up twice, so we'll skip through that. Okay, this is the as-is sale of property due diligence addendum to sales contract. NABOR did not used to have an as-is sales contract with the right to inspect and terminate. Okay, only FAR/BAR did. So in order to create that from a residential real estate sales contract, we have this form which effectively says that the buyer it replaces the inspection provisions under the sales contract. The buyer has X number of days after the effective date to evaluate the property. It's 15 days if left blank. That's the same as the standard inspection period. Be careful when you knock those out to 0 because the inspection period also includes permit searches. So if you give 0 time to do any inspections, That gives 0 time to do permit inspections as well. Okay, so in any event, this can convert that. Now, why do we still have the form? There was some talk about getting rid of it since we have an as-is sale contract form with right to inspect. We kept the form in the event that you guys are working on a sale and somebody wants to turn a residential sales contract into an as-is right to inspect arrangement. Okay, we can attach this and then we're good to go. Okay, it doesn't happen very often, but it does. So it's there for the flexibility of starting one way and converting to another. Kind of like being a transaction broker, being a single agent, converting to a transaction broker, okay? All right. That's in there twice. Amendment of sales contract. Closing date change. Easy form to change the closing date. But remember, every time we're doing these things, even though the parties are agreeing to everything, it's really a good idea if we're changing the closing date, get everybody to agree in writing, okay? And here is a form that I see this is an area where we're going to extend something, the timeline for doing something. It's a great form. I don't see it used very often. Anybody here ever use this form? Okay. What I do see is something that's handwritten or a little email back and forth. Okay. And keep in mind that texts are not emails. Texts are not writings. Texts do not form or amend contracts. So do not use text. Generation Z loves texts, but they don't work. Okay. Under the Electronic Signature Act, and under law in every state I'm aware of, texts do not create contract documents. Okay, so but this form here, you can extend the closing date, financing contingency period, inspection period, due diligence in the as-is contract, title examination period. Remember, under the sales contract, the title examination period is 30 days from the effective date. Okay, so we might want a little bit longer time. And then we have clearance period to clear any title issues or survey problems. Okay, we can extend that as well. So I like this form because it really does a good job for you, and you might want to consider using it next time you want to extend something. But at least you know it exists. Okay, not seeing this a lot anymore. COVID-19. So we had some issues with the COVID-19, so we created a form to address that. This is one of the few forms that we've done something before the biannual revision of the forms. We revise the NABOR sales contract forms every 2 years, and in between, if needed, we revise them when Dodd-Frank created all these rules about seller financing, and we revised it when COVID-19 kind of made a train wreck out of so much. But here, seller and buyer acknowledged that COVID-19 was a pandemic, may cause unprecedented impacts on real estate transactions, and if not yet passed, seller and buyer agree to extend the following dates and or time periods. So we've kind of taken the extension addendum and amendment, and we just turned it into a COVID-19. And we did that because we thought that it was a lot easier to get things extended when you went to somebody and said, look, COVID-19 screwed everything up, so we need 30 more days to close, or we need more time for financing, whatever it might be. Okay. Okay. Then we've got, it's not an amendment to the contract, but a lot of realtors don't know this exists. Can you square that up for me? Timeline of events. Okay, this is a form that, and we update this every time we update the contracts. So this is based on the deadlines in the contract. I think it would be a good idea for you to use this form because it's one more way that you can be professional with your customer and say, hey, here's deadlines in the contract. I'm going to share this with you. And I don't know how you want to use it, but I think it works pretty well, and it lays out all the things. And even over here, a little checklist of what's been going on. You can even update them on here's the status and checklist and send it to them periodically. Yes, ma'am?
For simplicity, you can do it. You can put the information in, and it will send you reminders.
Okay, I didn't know that, so thank you.
Then it does exactly all of it.
Okay, so you ever heard that in Form Simplicity? You put the information in, and it will send you reminders. And one of the ones that I think that you could always use a reminder on is
15 days.
yeah, the 15 days is good, but buyer's title examination period. I'm just looking at things that you guys should be really paying attention to. The inspection deadline is important, but I think everybody really pays attention to that. But the title objection period, that's pretty much a drop dead date, even though it doesn't say time is of the essence. So if we haven't taken care of that by that deadline, then it can be an issue. So that's one to look at. The other one that to me is important is buyer's titling instructions, which is 15 days before closing. I continue to have problems. We represent sellers, and I cannot get whoever's working with the buyer to tell me how the buyer wants to take title. And we get to a point that we got to send our documents to get them signed and get ready to close. And I still 2 or 3 days before closing, I just still don't have anything as to how the buyer wants to take title. So you guys can help a lot making sure that gets done just by bird dogging your deals. That'll keep everybody happy. Okay. This addendum to sales contract purchase price escalation. Okay, this was a form that we really created because the market was doing so hot, and somebody would offer money, but they would be willing to make a higher offer, but they didn't want to put the higher offer in. So this says that if the seller receives one or more competing offers from bona fide arm's length third-party buyers, okay, we can always argue about that later on, but which are acceptable to seller, which have a purchase price equal to or greater than the purchase price stated in this offer, the purchase price in this offer shall automatically increase by whatever the escalating factor is, in excess of the highest purchase price in such competing offers, not to exceed a purchase price of blank. Okay. If the increased purchase price exceeds the maximum purchase price, the buyer's offer shall be the maximum purchase price. If the competing offer includes escalating factor, the escalating factor contained herein can be used multiple times up to the maximum purchase price. So everybody understand how this works. Okay. What I always was surprised with is, it escalates, and here's not to exceed. I know. Why would you just not make an offer at the not to exceed? Okay. I know why you wouldn't, because the buyer's cheap and they don't want to pay more than they have to. But you just told the seller, in the offer, here's your max. Now, if I'm listing agent, my seller said, what should I do? I'd say, I think you ought to tell them you'll take this. We have a deal, okay? But I laugh at this form, but it is what it is, okay? And that's there because, while we're drafting the form, people go, well, you can't have it going on forever. You got to put a cap. Okay, well, here it is, okay? So it does tell the seller an awful lot of information, but, it is what it is, okay? Now, it might not be a horrible thing. We did have that deal that I used to, I've got 12 offers. We're looking at them all on Friday or Tuesday, whatever it might be. Well, at least you got that there, so at least it was something. Okay. All right. Addendum to sales contract, insurance unavailability due to extreme weather conditions. Okay. If due to an actual pending or threatened hurricane, tropical storm, etc., we can't get, basically it'll be windstorm coverage, right? Or homeowners casualty insurance, then a reasonable rate for closing, buyer may delay the closing until the date which is not more than 5 days after the insurance coverage becomes available. It's not available for 30 continuous days, either party can terminate, okay? So that's not a bad form to have. We do have, the contract says that if there's unavailability of things, we can extend the closing. But, if the storm comes into the zone, we can't get any windstorm coverage. So that may be a form to use during the summer months in particular. Okay. And that's all our addenda and amendments. Anybody have any questions about any of those?
And whether when your office would do that anyway, really.
Well, the contract form itself does give us an extension for unavailability of things. And unavailability of insurance probably puts us okay with that. But this one I like because it really gets away from an argument, because then this one, no matter what, it doesn't have the seller, well, of course, always somebody comes back and argues. I think this shortcuts the seller arguing that the buyer applied late, and that's the problem. The buyer didn't apply, and that's why they can't get insurance now, because there's a string of 3 hurricanes coming through the Caribbean, and they're all going to be in the zone for the next 2 weeks, even though none of them are going to hit us. Yes, ma'am.
What do you suggest if you have somebody, usually from up north, they want their attorneys to look at the contract, the attorneys want to justify what they're charging the buyer, and you're crossing out things in the contract, and they,
Well,
what do you suggest?
when you've got the attorney up north monkeying around with a Florida real estate transaction, and they often do cause trouble because they want to cross things out and wholesale and whatever they do. you definitely need a lawyer here to kind of counter that, okay? But insofar as how does that affect the transaction, it really depends on how bad they want to hack up the contract. Sometimes, even though they might hack up some things, it's not particularly harmful to the other side. Sometimes what they do makes no sense, or it's just, it won't work under Florida law. And if what they've done doesn't work under Florida law, well, now we have a contract that may be unenforceable, and either party could terminate it no matter who monkeyed around with it. So I feel your pain on that. I cringe when there's out-of-state lawyers that want to get involved with the transaction. I'm working on right now with somebody from Arkansas, and the guy's really good to work with, and I'm having a problem. And he said, why don't you do all the documents? And I go, okay, so we're going to close this when it's going to be okay. But, it's usually the upper Midwest that we get some of these folks, and then it's problematic because I don't know why they're inserting themselves into a Florida real estate transaction, because I don't think they really should be doing it. I think it may be unlicensed practice of law in Florida, and I think they're really doing a disservice, but they do it. So all I can tell you is it's...
So if they're licensed, say, in New York, and they're messing with the contract, you have to have a license in every state?
Well, I think the argument would be they're working in New York, they're doing it in New York, they're providing advice to their client as their New York attorney and all that. So I think they're probably off the hook. But, it's just as bad for me as it is for you, because an out-of-state attorney that wants to get involved with a Florida, especially a residential real estate transaction, has no business doing that to begin with, and either is worried about losing a client or is just trying to get a fee for being involved with something. They shouldn't be monkeying around with it all. They should be referring it to some other attorney in Florida that has some experience doing real estate transactions. So that being said, tells you that's the problem, is they shouldn't be involved with it to begin with, so we all have to work with it. Okay. Hope that's not being recorded. Just kidding. Anybody else? Everybody feel her pain on the out-of-state attorney being involved with the transaction? Okay. All right. All right, that's it, guys. We're out a little bit early, so I hope you have a great day.